lots of fun to we move along so merrily. Let's take sweet April strolling. Here's your bottle, sweet April dear. Push her button, she sheds a tear. I'm the one who guides her feet, and here we go, step by step. Love her so, it's such a treat to take sweet April strolling.
Sweet April comes with her walker trainer and bottle from Rimco.
Put two freewheeling cars on a track with no lanes and no grooves, and you're in for some wild racing. Introducing accelerators from Aurora, the electric racing set that doesn't need slots. Racing cars that freewheel all over the track because there's nothing to hold them down. With your accelerator power stick, give them juice to pass, or try to. Swing out on that curve. The action never lets up because the transformer plugs right into the wall. The accelerator Sideswipers race set comes with two freewheeling cars, plus everything you see here. From Aurora.
Channel 2, New York.
This is a special report from CBS News in Washington. Here is CBS News correspondent Nelson Benton.
This is the National Press Club in Washington, where Special Watergate Prosecutor Archibald Cox is holding a news conference in a few moments to discuss the president's action of last night on the Watergate tapes. The White House announcing that rather than appealing to the Supreme Court, an appeals court order to turn the tapes over to Cox, it would provide a summary of the tapes, both to Cox and to the Watergate Committee. With Mississippi's Senator John Stennis having unlimited access to the tapes themselves, Senator Stennis selected by the White House to verify the completeness and the accuracy of the summaries. Special Prosecutor Cox interpreted that as a presidential refusal to obey the decrees of the courts that would require him to violate the solemn pledge that he made to the Senate and to the country when he took office as the special prosecutor. He said last night that he would have more to say a little bit later on, and in this setting today at the National Press Club, Archibald Cox will have more to say. We see Mr. Cox coming into the National Press Club ballroom now with Mrs. Cox, and we'll watch and listen.
Ladies and gentlemen, I'm sorry to have had to bring you in on such a lovely day. There were three reasons for asking you to come in today. One, I wanted to give you the background of the events of last night, including some of the relevant papers that led up to them. Second, it seemed to me that having taken a stand that attracted some attention, that I owed it to you and to the public to try and answer as many of your questions as I properly can. There are still some limitations on what a prosecutor can say in public. And third, I thought I wanted to say just a word or two about my personal attitude in this matter. I sort of hoped you would understand it, and it may be too personal, but I'll try. I read in one of the newspapers this morning the headline, Cox Defiant. I do want to say that I don't feel defiant. In fact, I told my wife this morning I hate a fight. Some things I feel very deeply about are at stake, and I hope that I can explain and defend them steadfastly. I'm not looking for a confrontation. I've worried a good deal through my life about the problems of imposing too much strain upon our constitutional institutions, and I'm certainly not out to get the President of the United States. I'm even worried, to put it in colloquial terms, that I'm getting too big for my britches, that what I see as principle could be vanity. I hope not. In the end, I decided that I had to try to stick by what I thought was right. Let me try to tell you what seems to me to be the essence of the current problem. And I'm sorry that this was put together so hastily that it'll be a little long. As you all know, there has been and is evidence, not proof perhaps in some instances, but clearly prima facie evidence of serious wrongdoing on the part of high government officials. Wrongdoing involving an effort to cover up other wrongdoing. It appeared that papers, documents, and recordings of conversations in the White House, including the tapes, would be relevant to getting the truth about those incidents. I'm referring not only to the Watergate incident itself, but to other things involving electronic surveillance, break-ins at a doctor's office, and the like. Two courts have ruled that, with some exclusions, not only the tapes of 9 conversations, but some very important papers, memoranda, and other documents bearing on those conversations are relevant and should be supplied to pursue the investigation. Last night we were told that the court order would not be obeyed, that the papers, memoranda, and documents of that kind would not be provided at all, and that instead of the tapes, a summary of what they show would be provided. I think it is my duty as the special prosecutor, as an officer of the court, and as the representative of the grand jury, to bring to the court's attention what seems to me to be non-compliance with the court's order. If the court should rule that there was satisfactory compliance, then it would be my duty in those same capacities to abide by the court's order, and of course I would, and we would go about our business as best we can. That's what I regard as the basic adherence to our institutions of justice, which should be applied and followed in dealing with these problems. You will say, well, so far as the tapes are concerned, forget legalisms. Isn't this a pretty good practical arrangement? I find four, to my way of thinking, insuperable difficulties with it. First, when criminal wrongdoing is the subject of investigation, and when one of those subjects is obstruction of justice in the form of a cover-up, then it seems to me it is simply not enough to make a compromise in which the real evidence is available only to 2 or 3 men operating in secrecy, all but one of them, the aides to the president, and men who have been associated with those who are the subject of the investigation. It's not a question of Senator Stennis's integrity. I have no doubt at all of Senator Stennis's personal integrity. But it seems to me that it's the kind of question where it is terribly important to adhere to the established institutions and not to accommodate it by some private arrangement involving, as I say, submitting the evidence ultimately to any one man. My second difficulty is that I will not know, and no one else will know, what standards have been applied in deciding what to exclude from the summary. For example, when I give you the various written proposals and comments that were exchanged, you will find that it is contemplated that there will be omitted references to matters related to the national defense or foreign policy whose disclosure would do real harm. I am very troubled by the lack of precision in those standards. We all know from matters that have been published that the Ellsberg fielding break-in was described as matters affecting the national defense, and that the tapping of William Sapphire's and John Sears telephones was apparently treated as a national security matter. Those certainly raise very serious questions as to whether criminal wrongdoing was not involved, although I must emphasize that I do not prejudge it. I just say they raise serious questions. My third reason for thinking that as a practical matter, I, as charged with prosecuting violations, could not regard the arrangement as satisfactory, is that it's most unlikely, I don't go beyond that, most unlikely that a summary of the tapes would be admissible in evidence. It would be satisfactory for the purposes of a grand jury, I think, but I'm thinking of the actual conduct of a trial. And if that was all that was available, and I was given to understand that the tapes would never be available under any circumstances, then I would be left without the evidence with which to prosecute people whom I had used the summaries perhaps to indict. Similarly, you have all read of cases in which those who have been charged with wrongdoing have said that they need the tapes in order to make their defenses. Again, it seems to me most unlikely that a summary would be accepted by the defendants or that a court would regard it as sufficient. And that could very well mean that those prosecutions would have to be dropped. In my statement last night, I pointed out that we were on the verge of such a problem in the prosecution of John Mitchell and Maurice Stans in the Vesco case in New York. Since then, there has been some suggestion, I understand by hearsay from the White House, that maybe those tapes would be made available, or a transcript of them. I can't think that the two are unrelated. The other main part of the President's statement last night said that I would be instructed not to use the judicial process in order to obtain tapes, documents, memoranda relating to other presidential conversations. This instructs me not to pursue what would be the normal course of a prosecutor's duty in conducting this kind of investigation. And I think the instructions are inconsistent with pledges that were made to the United States Senate and through the Senate to the American people before I was appointed and before Attorney General Richardson's nomination was confirmed. If you go through the hearings, you will find repeated pledges by both of us that I should have complete independence to decide how to conduct these investigations and prosecutions, and particularly complete independence in determining what evidence to seek. There were also specific references to executive privilege and pledges by me and by the Attorney General that I not only would, in his view, be free to contest, but on my promise to the Senate, that I would contest claims of executive privilege where I thought the evidence was material. This was finally summarized in the so-called guidelines and the departmental order put out by the Attorney General. It reads, the Attorney General will not countermand or interfere with the special prosecutor's decisions or actions. The special prosecutor will determine whether and to what extent he will inform or consult with the Attorney General about the conduct of his duties and responsibilities. The special prosecutor will not be removed from his duties for extraordinary improprieties on his part. I do want to emphasize that the giving of instructions in this very important respect isn't important because it interferes with Archie Cox. It's sort of embarrassing to be put in a position to say, well, I don't want the President of the United States to tell me what to do. I was brought up with the greatest respect for every President of the United States. But that isn't what's involved. It's that there's a basic change in the institutional arrangement that was established. There was a widespread feeling that there was need for an investigation conducted by someone wholly outside the administration who believed in the normal processes of the grand jury and the courts, who would follow them and adhere to them, and who wouldn't be subject to instructions that might call him off or impede his work. And the purpose of this was to make it plain that the country would get such an investigation. It happened to be me. It may have been a good choice or a bad choice. But this changes it. And I don't think I could properly go on without making it plain that there had been a change. And indeed, I would have no interest in going on if there really was to be a radical change. But it wouldn't be right to continue with the pretense that we had the old arrangement while it was changed and instructions bearing on enormously important aspects of the duty had been given, and if they can be given once, then of course they can be given in the future. And I'm afraid if I acquiesced in them once in the hopes of avoiding a confrontation, and as I say, I don't like confrontations, then I would find myself saying, well, it isn't worth doing it this time either. So it seemed to me that I ought to make plain what was happening. Now I turn to a bit of background. When the Court of Appeals first handed down its memorandum, no, let me go a little bit back of that. The incidents of last night need to be viewed against two things. One is the whole problem of obtaining information for this investigation. And the other is the immediate discussions that took place between me and various representatives of the President. It's my characterization, but all I can say is that my efforts to get information beginning in May have been the subject of repeated frustration. This is a very special investigation in some way. The problem is unique because nearly all the evidence bearing not only on the Watergate incident and the alleged cover-up, but on the activities of the plumbers and other things of that kind, is in the White House papers and files. And unless you have access to those, you're not able to get the normal kind of information that a prosecutor must seek. And written documentary evidence is far more reliable in a situation of this kind than the recollection of any witness, and certainly of interested witnesses. As I say, it seems to me that the record has been pretty much one of frustration, either through delays or refusals to provide things we asked. I haven't made a great point of it. While the legal question was being tested, it seemed to me that it would be right for the President's Counsel to say, well, let's get the law settled on these points, and then we can go on from there. And that it would be unfair of me, while the litigation was pending, to attempt to put public pressure on counsel to the President in these respects. But now, at least as of the moment, there's a question whether we can test the legal question. Let me give you an example. You will recall that the papers of many White House aides, Haldeman, Ehrlichman, Krogh, Young, Dean, and others, were taken into custody, and they're in a special room. And many of their papers were taken out of the usual files and put in something special called presidential files. Back in June, early June, if my memory is right, I asked that an inventory be made of those papers. I recognized that some of them might contain information that I shouldn't see, but I thought that if there was to be any thorough investigation, that at least we ought to know what papers were there. I've never gotten it. I was told orally over the telephone a short time ago. I don't mean in connection with the current incidents, but a few weeks ago, that the inventory would not be furnished. There have been other papers that we've sought to get, and while I must say that I've been told I would receive them, the delays have been extraordinary. For example, I asked for all kinds of logs of many principal names in these incidents, and I was promised them back in June. I still haven't got the logs of meetings of the President with such people as Chapin, Colson, Gray, Hunt, Kleindienst, Krogh, LaRue, Liddy, Strawn, or Young. I hope our records are accurate. There are many pending letter requests. And I can't help reading the instruction not to seek subpoenas against that background, even though this instruction, as it's written, refers only to things referring to presidential conversations. And I think I'm entitled to suggest that the thing should be judged against that background. Well, then we come to the immediate incidents, and then I'll be through with this perhaps too long account. You'll remember that the Court of Appeals, after oral argument and before it rendered its decision, suggested that there be an effort to reach a mutually satisfactory accommodation in which the President or his representative and I would agree what parts of the tapes should be made available to the grand jury and what parts should be not. I had conversations chiefly with Fred Bizart. They were conducted under pledge of confidentiality. I do not think I ought to violate that pledge. I do think it's proper to say just one thing. I did submit a fairly carefully drafted 6 or 7 page proposed procedure for resolving these questions. I referred to it again within the last week. I have no objection to giving it out, but I don't feel that I am at liberty to do so in view of the promise that I made. I hope I'm not breaking that promise and even referring to it, but it does seem to me to be an essential part of the background. The end of last week, the Attorney General and I were in touch with each other. We had several candid, frank, and very friendly conversations. Indeed, I want to make it plain that at the end of last week and all through this week, the Attorney General has behaved in a way that makes it just as possible for me to say with as complete sincerity as I said at the Senate Judiciary Committee when we were up at the hearing on his confirmation, that I have admiration, respect, and affection for the Attorney General. And I emphasize that to all of you. The conversations ended in a document headed a proposal. You will see his initials on it, and he knows, in this case, I'm not breaking any promise of confidentiality. He knows that I'm going to give it to you. At least he knows that I might give it to you and that I was free to. It set forth, I'm not going to stop, for you'll all see it. It set forth a plan, somewhat like what was announced yesterday, last night, except that it was in more contingent form, and I think it was meant to leave room for discussion. I wrote him on October 10 a paper called Comments on a Proposal, and we will give you that too. I would emphasize only a few points about it. I did make to him the point I made to you a few moments ago, that I thought the public cannot be fairly asked to confide so difficult and responsible a task to any one man operating in secrecy and consulting only with the White House. Another main point I made was that the object of the proposal was stated too narrowly, that it referred only to Watergate, whereas the things that I have been charged with investigating are a great deal broader, and that I had reason to wish to use the evidence in connection with them too. I made the points that the standards needed to be stated with more specificity so that there could be no misunderstanding about what the slippery term national defense or national security means. I referred to the problem that an edited version might not be admissible in evidence. I also noted, I guess this is not of great significance, but you might want to observe it. My 10th point was I am puzzled about the practical and political links between our agreeing upon a proposal and the demands of the Irvin Committee. There was no response to me that we're in touch with the Irvin Committee. I learned that when I read the President's statement last night. Let's see, Thursday night, if my memory is correct. I received word that I was to call Marshal Wright at the White House in General Haig's office. Marshal Wright turned out to be Charlie when he came on the phone, and he quickly acknowledged that he was Charlie. And he referred to my comments, said that there were 4 stipulations that he must make that would be essential to any agreement. And as I understood him, he said, you won't agree to these. Indeed, the impression I got, and I want to make it clear that it was my impression, maybe there are tapes that would verify my impression, or maybe my impression is wrong. But it was my impression that I was being confronted with things that were drawn in such a way that I could not accept them. You will find that there's some differences between his summary of the 4 points and mine. All I can tell you is that mine are right to the best of my recollection, and he can speak for himself. I replied that I was in a difficult position. I was sitting on the floor at my brother's house. We were in the middle of dinner. In point of fact, his children were all over the place and filled with excitement, trying to hear what was on the phone and so forth, and that I didn't think that I ought to be put in the position of giving a response under those conditions. But that neither did I wish to imply that there should be any optimism about agreeing to them. I then went on and suggested, why don't you dictate what the 4 points are, and I can look at them tomorrow morning and then give you a reply. And we will give you his letter, which I received, my response, and then one final letter, which suggested that I had misunderstood the scope of some of the things he said. That came at 23 minutes past 5 yesterday. My letter was delivered about 10 o'clock. There was ample time to explain if I had misunderstood anything of critical importance. Well, there's the account. I apologize to you for being so professorially long-winded. I wanted you to have it and to be as candid as I could, and I'm glad to answer questions for as long as your patience and my strength hold out. Yes, Pete.
Mr. Cox, you would seem to be in what we'd call a non-viable position now. Are you going to wait for the President to dismiss you?
I'm going to go about my duties on the terms on which I assumed them.
What is your duties now?
My duties are set forth. My duties, as I understand them, are those set forth in the departmental order, in the Attorney General's references, that's perhaps the wrong word, in the Attorney General's statements to the Senate Judiciary Committee, and in my pledges to the Senate Judiciary Committee.
I wish to be specific and had not gotten there. What do you consider to be the state of the case now? And if you will go into court, what court and what will you say?
Well, I'll try and be as precise in answer to that as I can. I should tell you that there are some legal questions that we would have to look up. It is my intention, with reference to the order of the Court of Appeals and the District Court, to call to the attention of one or the other, and I'm not sure yet which is correct, the fact that the papers, documents, and other things subpoenaed are being refused, and that the order to deliver the tapes, subject to some particular reservations, is certainly not being satisfied. Also, I would also add that a summary is being offered and would express the opinion that that was not adequate. Now, technically, the first thing we have to be sure of is the mandate issues. The second thing we have to decide is which of the two courts has jurisdiction. I think the district court clearly has jurisdiction. I think that the Court of Appeals may also have jurisdiction, in which case I would have to make a choice whether to go to the seven-man tribunal or to Judge Sirica. One form of procedure would be to seek an order to show cause why the respondent should not be adjudicated guilty of contempt. I think it may also be possible, and perhaps might be preferable, to seek a further order clarifying any possible doubt resulting from the President's statement last night. We will have to make that kind of choice. Yes.
Mr. Cox, is not your intention in direct conflict with the President's order to you? And if it is, and you're fired by the end of this news conference, what happens then?
Well, there are a number of other technical questions. I was appointed by the Attorney General. Under the statutes, the Attorney General and those to whom he delegates authority are in charge of all litigation, including the obtaining of evidence. I think there is a question whether anyone other than the Attorney General can give me any instructions that I have any legal obligation to obey. Second, under the Constitution and the statutes, there are instances in which not the President, but departmental heads make appointments. And I would think that it was a proper inference that where departmental heads are authorized by statute to make appointments, that the same departmental heads are the only ones who can make dismissals. I don't mean to seem to cling to power or office. If my personal ease were the test, I'd be on the coast of Maine and not here. But I do think it important to do everything I can to emphasize the extent of the departure from the kind of detached, independent public inquiry which the Senate caused to be set up. And once I have done everything I can to make that clear, then I'd be happy to relax.
Let me just...
I have a couple of points I'd like to clear up.
Sure.
Number one, I believe you said that you were told orally that you would not be receiving the logs that you asked for, or at least the inventory of the papers that you had requested. Just to clear that up, who told you orally that you would not?
Fred Desart. I've been dealing with Fred Desart, and I may say, too, that he has behaved. I don't mean to be drawing any distinctions here, but I'm not criticizing him personally. He's behaved in dealing with me in an entirely honorable way, except he's so damn slow.
Right, but in other words, and he was counsel at the time, counsel to the President at the time he told you that.
I didn't hear you, I'm sorry.
He was counsel to the President at the time he told you that you would not be receiving.
Right. Hasn't he been all summer? Yes.
Right, okay. The other thing you mentioned, as I understood it, you'd said earlier that you had heard by word by hearsay that the White House was saying that it was possible that you might receive some tapes concerning John Mitchell and Marie Stans in the Vesco case. Just how did you hear that? by hearsay, and in effect, then, aren't they giving you aren't they saying that they would be giving you some of the tapes?
Well, might.
How can you say how you heard by hearsay?
Through other lawyers for the government who are concerned with the case.
Was this White House lawyers, in other words?
No, not directly. That's why I say it's hearsay.
Mr. Cox, have the instructions referred to in the President's statement last night been conveyed to you by the President, the Attorney General, or anybody else?
All I have is a copy or copies of the statements that I received through the courtesy of one of the newspaper offices last night. I can't put in a plug for them, but it was a newspaper. Nothing has been communicated. Yes, nothing has been communicated to me personally.
Mr. Cox, what makes you believe that Attorney General Richardson will not fire you, following President Nixon?
He may. I'm not saying that no one can fire me. Of course, eventually, there are ways of firing me. I don't know what Attorney Richardson will do. I've told you my judgment of how he has behaved all week, and I stick by it. Now, eventually, a president can always work his will. You remember when Andrew Jackson wanted to take the deposits from the Bank of the United States, and his Secretary of the Treasury wouldn't do it, he fired him. And then he appointed a new Secretary of the Treasury, and he wouldn't do it, and he fired him. And finally, he got a third who would. And that's one way of proceeding.
Mr. Cox, in your comments here on the logs of the President's conversations with Chapin, Colson...
No, this was simply, let me make one thing clear, Cox. These were not transcripts or tapes. They were simply diaries, as it were.
Well, you had Liddy's name listed in that group.
Yes.
Was there a conversation between the President and Liddy?
I did not mean to imply affirmatively that there was such a conversation.
Mr. Cox, could you just specify for us what these memoranda, papers, and documents are that you're not going to get, the specific, or characterize them in some way to indicate what they are?
The ones that I am most aware of are notes that would have been made by John Ehrlichman on every conversation in which he participated. Now, this would be important in case any part of the tapes was inaudible or garbled in some way, or if it was ambiguous. It's quite possible that those notes not only set forth his understanding of what was agreed upon, what was to be done, but would give some background of the knowledge which he had against which they were to be read. Another example is, I don't know, and that's why you issue subpoenas, but I have reason to believe that in addition to the conversation with John Dean on April 15, there is a memorandum of that conversation dictated by the President himself. That would give his understanding in the event that any part of it should be inaudible or ambiguous or something of that kind. It's that kind of thing, Tony, that makes me think that we should get as much light as we can. One of the ironies of this, of course, may be that if one got them all, it wouldn't be any light.
Cox, would you say that this latest series of events in this entire episode of last night, the situation in which you find yourself, is simply another episode in the very cover-up that you went out to investigate in the first place?
I don't want to engage in any general characterizations. Yes, excuse me, you've been very patient.
Sir, you're rather unique in our history because you personally rebuffed the President of the United States. We saw you come in here today whole-handing with your wife, and I'm sure it took a lot of moral courage. But do you think if the President of the United States continues to rebuff you and the courts in giving this evidence that he ought to be impeached?
I'm sorry, I don't want to do any more than explain my views about and my conduct at the present juncture.
Did you
And
ever...
I think that kind of conclusion is something for others to reach. If I reach any conclusions about it in my official or public capacity, I'll make them clear. But I don't think this is the time.
May I follow up on that?
Mr. Cox, you told us about the breakdown in the effort to reach an extrajudicial compromise along the lines suggested by the Court of Appeals before it handed down its decision. But you did not discuss its second suggestion for an extrajudicial compromise in the decision itself. That called for an agreement between you and the President. In your discussions with the Attorney General and the White House, did you point out that their proposals violated the suggestion made by the Court of Appeals?
Well, it has been quite clear that the President's representatives were not authorized to discuss with me any procedure that would involve my seeing or hearing the tapes. I think I could have been trusted to do my job honorably, but I suppose I appear as one who is somehow trying to provoke confrontations and out to get the President, which isn't my, as I see it, my aim at all. But it was quite clear to me, Izzy, that they weren't going to agree to anything along that line, and that for me to try to press that would be throwing gravel in the gears, and that I ought to try other things that I thought met the requirements of the kind of investigation that the Senate contemplated.
Mr. Cox, when do you expect to go to court, whatever court it is you go to?
Well, promptly. I mean, as fast as we can be sure that we're right.
Would this coming week be a fair guess?
Well, it's certainly a fair guess, and certainly I would hope to.
Mr. Cox, is it your position that only you or a judge can properly determine the relevance of parts of those tapes, and that no senator, no matter how competent or distinguished, is in a position that you or an officer of the court are to adequately assess the tapes?
Well, I think that, no, I wouldn't go that far. I would say two things. I would say that the requirements of a careful, knowledgeable, and responsible appraisal requires something more than any one man operating in utter secrecy by agreement. Second, I have to think of the subsequent court proceedings down the road. And I do think that it is most unlikely, that's as far as I can go, the law is uncertain. I think it is most unlikely, indeed in my judgment impossible, that at a trial any but a judicial determination of what parts of the tapes must be provided would be accepted.
Mr. Cox, one follow-up question. May I ask you to state once more and clarify or amplify, if possible, the two questions that you said you saw a possibility of exploring in court. You mentioned the possibility of contempt here, and you also said that you'd like to explore the possibility of seeking an order clarifying, I believe, the President's statement of last night in some way. Could you amplify on those two questions?
I'm afraid I don't understand your question. Probably should, but I don't.
Mr. Cox, could you, is there any compromise that you could approve that you would find telling us?
Well, you look at the papers. Well, I'm sorry. They will be available to you, and I hope that they will make clear the lines along which I was willing to explore. I don't think you know until you try. There were things I was willing to try.
Sir, a lot of people in the country have wondered why you took this job and how you ever expected to succeed since you were working for the Justice Department, for the Attorney General who was appointed by the President. And now you say the Attorney General is going against the agreement he made with the Senate when he was confirmed.
I said no such thing.
You did not?
No.
Well,
I did not.
Do
I
that?
said the Attorney General has behaved all week
I know you
as
said
an honorable friend, and he has not violated any agreement
But
that
did
he
he
made.
not go against his agreement with the Senate by
No, he
asking
did not.
you to take
He-
this?
He has not violated his agreement in the Senate, so far as I know, in any way whatsoever.
Well, then my question, sir, was how could you expect to succeed in this job? How could you expect to succeed?
Well, I thought it was worth a try. I thought it was important. If it could be done, I thought it would help the country. And if I lost, what the hell?
Mr. Cox, let me ask you about... Excuse me, Mr. Cox. The reporters over here are...
I'm sorry. I'm very sorry. Yes, go ahead, Hayes.
Mr. Cox, there was a lot of talk this week by Republicans on the Hill.
A lot of what?
A lot of talk by Republicans on the Hill that if the President defied a Supreme Court order to give up the tapes, that then he would likely be impeached or an impeachment action would begin. Do you regard him as of this moment in defiance of an appeals court order, a definitive appeals court order?
In my view, the President has stated that he would not comply with the appeals court order. That is my view. I think it so likely that he is not in compliance that it is my duty to present the question to the court. It would then be for the court to make the determination. I'm not the last word, thank God.
Mr. Cox, we were told you had a conversation last night, 7:45, with the Attorney General. Could you tell us about that conversation and what his expressions were concerning the way this whole thing has turned out?
I would rather you didn't press that. It's not, I think that was between old friends. And it's not, I really don't think that I'm holding back anything that is necessary to your understanding. I feel that it's be subject to misunderstanding by him.
Mr. Cox, we've been under the impression that the delay in the work of the Watergate 1 grand jury was because you had been unable to get the tapes. Is it true, based on what you said here today, that perhaps another barrier, maybe the principal barrier, has been that you've been unable to get other evidence that you've been seeking from the White House?
No, I think that in terms of the inquiry into the Watergate matter, that the most important cause of the expenditure of time has been our feeling that we should not proceed until we got the evidence covered by this subpoena. We have also had many, many other things to do. As I think I said to some of you earlier, was it this week? This is an investigation in which new things, sometimes written documentary things, keep turning up at the last minute, and they force you to go back and say, oh, my God, maybe we've all misunderstood what happened. And this has hit us on several occasions. Also, I don't mean to imply that we have all misunderstood what happened. I've still got some people over here.
Would you tell us, there was an inference in your earlier statement that you would accept the decision of these lower courts, whatever it is. Supposing these lower courts, either one or both, find that this is a reasonable compromise or something similar is a reasonable compromise, would you accept that and go on with your work?
You mean instead of obtaining the view of a higher court?
Yes.
Oh, I would have to decide that when I came to it. I don't think I can prejudge that in advance. You know, it would depend on how persuasive its opinion was, other things of that kind. I am here to conduct this investigation through established institutions, and that's what I intend to adhere to, and I intend to be guided by them. I am just one party before the courts.
Cox, should you be removed from office, would Judge Sirica or the appeals court have the authority to move on their own in an attempt to force the president to release the tapes?
I think that the answer is a very probably yes. It is even possible that I could be appointed counsel, the grand jury or the court for that purpose. But don't carry that too far. The thought went through my mind, and then I also concluded, no, I think that would be of very doubtful propriety, because it would then turn what ought to be a question of principle into something that somebody would look on as a personal fight, and I don't think this is a question of personalities.
Mr. Cox, you give us the impression that you're responsible to the Attorney General and not the President. And you hark back to President Jackson going from one Treasury Secretary after another until he found one that would do his bidding. Are you under the impression that the Attorney General is going to side with you and not the President in this issue?
I can't tell you because I don't know what the Attorney General is going to do.
Mr. Cox,
anyone else? I guess those are all my staff over there.
Mr. Cox,
you haven't had a turn.
Yes, Mr. Cox, you covered in your statement the legal roadblocks that would develop as a result of not getting the tapes. But what you did not say is whether you are convinced that you will lose every case, Watergate and Watergate related. Are you convinced that you will lose those cases?
Think what the defendant's lawyers would do to me if I ever said that that was my frame of mind.
Mr. Cox, the compromise has been stated to have been Richardson's brainchild. Is that accurate as you understand it, or do you feel that that was foisted upon him by the White House, the President's lawyers?
Well, all I can say to you is that you should put the proposal, which Jim will give you, if he hasn't already, next to the President's statement, and draw your own inferences. The only other thing, as you know, Clark, things that anyone does in government are the result of discussion and such among many people. I don't know what his own personal druthers would have been in this. He gave me the proposal, and I am sure he stood behind it.
Mr. Cox, have you been in touch with anyone directly or indirectly who might be a representative for the White House within the past, say, 12 hours concerning your future tenure in your present job?
I talked to the Attorney General on the phone 5 seconds before I came into the room. It had nothing to do with my future tenure. It was, again, a purely friendly conversation. I mention it only so that my answer will be 100% accurate. I have not talked to anyone else who could...
He called you in an effort to influence this press conference?
No, he did not.
Mr. Cox, so much has been made of the tapes that I'd like to ask you whether you consider the tapes absolutely vital to the case you're developing.
I think it is vital to know whether they're vital. I think the important thing is that here are conversations that there has been testimony about by one witness that would make those conversations enormously important.
For the better part of an hour, Special Watergate Prosecutor Archibald Cox has been giving background on his confrontation with the White House over the White House tapes. He said essentially that he had serious doubt as to whether or not he could get evidence admitted into a trial if it came only in summary form from the White House. He said that he had no doubts about the integrity of Senator John Stennis of Mississippi, who the president had designated as sort of an honest broker and go-between in giving summaries of those, or in confirming the accuracy of those summaries that would be given to the special prosecutor and to the Senate Watergate Committee. Further developments, reaction, and analysis of the Cox News Conference and the White House tape story will be broadcast tonight on the CBS Evening News with Dan Rather. Nelson Benton, CBS News, Washington.
This has been a special report from CBS News in Washington. This is CBS.